to answer questions pertaining to that, we are now joined in the studio by Professor Dunia Zongwe, an author, consultant, and an academic who recently did this, who touched on this subject. We are also joined by Brian Nazo, researcher at the University of Namibia. He's also just going to give us a brief on this topic. Just to start off, perhaps we can start with you, Mr. Zongwe. Just both research papers highlight a significant gap between Namibia's constitution promises of justice for all and a current reality. Perhaps can you explain how our constitution rather guarantees access to justice and why these guarantees aren't being fully realized 35 years after independence?
Yes, thank you very much for having me on the show. Article 1, the very first article of the Namibian Constitution, explains that the Namibian state is based on 3 fundamental values. One of them is access to justice. But access to justice, rather than a right, has become a luxury. Because if you look at the average income of Namibians and the residents of Namibia, and you look at how much it costs for them to get legal services, you realize that the majority of the people cannot afford legal services. My research indicates that about 90% of Namibians cannot afford to pay for legal services.
It is quite daunting or not a good feel, because you find some people representing themselves also in the courthouses, and I think that will be a good thing to see how this can be navigated. Perhaps Mr. Brian, if you can, your research shows that the marginalized communities, including women and indigenous groups like that of the Home, face particular challenges in accessing justice. What are the main barriers preventing this vulnerable population from accessing their constitutional rights?
Okay, I think the challenge that we have when it comes to barriers or people accessing justice is the local standard that is in place, which is, I would say, a colonial brick wall that people are struggling to enter the courts, because this particular legal frame or principle says that you should be aggrieved. Now, if you are representing a group of people, and most of those people are poor and they cannot afford, so if they approach, for example, Professor Zongwe to represent them, they'll say, you are not directly affected, so you cannot access. So that's one of the barriers. The local standard that is in place, the colonial principle that Namibian courts are holding on to, is the biggest barrier that is blocking these marginalized groups from accessing, or a particular group of people even to access the courts. If you have a person like Michael Amushelelo, we cannot represent a group of people, for example, in court, because they will tell him, you are not directly affected. So the local standard is the barrier.
Just the next question, we can start with you, Brian, and again go to Dunia to answer that. Both studies reference South Africa and India as an example of countries with more progressive approaches to legal access. Maybe just perhaps what specific lessons can Namibia learn from these jurisdictions, and how could they be adapted to our local context?
South Africa, for example, have this friend to the court approach, where a group of people can represent an affected community to the courts. And India have what we call the public interest litigation, where a person have a right to stand in the gap and represent. That's the approach they took, because they realized that everybody needs to be heard, either through an individual who might have access or resources to be heard in court. Namibia doesn't like that. They say, no, it's too much work, so the person should be affected directly to bring a case to the court. So that's basically what South Africa is doing differently, or India is doing differently from Namibia.
Okay. Yes, and you, Dunia?
Yes, just to complement what Mr. Guchinazo has said, you have at least 3 types of standing, which is the right to bring a claim in court. You have the individual one, which is what we have in Namibia. There is the representative one, where you can appear on behalf of a certain group, and then you have the public interest litigation. The Tsumib case, which Mr. Guchinazo has researched upon, showed that we are still stuck in the colonial ways, and standing was refused in their case because we are relying on this. So the barriers when we look at access to justice and local standards, they are actually fourfold. We have the procedural ones. That's the one we refer to when we talk about local standard or legal standing. There is the economic one, which is what I actually focus on in my own research. The geographic one, where people live far from the courts or from the court dispute resolution platforms. And then you have cultural ones. That is when, for example, the court doesn't recognize the customary collective rights, for example, of traditional communities like the one that Mr. Guchinhazo was researching upon.
So if we have to, just to you again, if you had to advise the Minister of Justice on 3 most urgent reforms needed to improve access to justice in Namibia, what would it be, and why are these priorities critical for our democracy?
I would say 3, yes. If I'm talking about 3 solutions, I would first say to pass, there was a bill that was proposed by the Law Reform and Development Commission about legal standing in civil actions. That would be a priority. The second one, it would be mandatory legal insurance. And then the third one, I would advocate for small claims court. It deals with the 4 types of barriers that I spoke about. The small claims court has the advantage of bringing justice closer to the people, and also it is accessible in terms of monetary jurisdiction. What I mean is that if a dispute falls below 50,000 Namibian dollars, people should be able to bring the claims. The Civil Action Act would help in broadening legal standing, moving away from the individual, the idea that we currently implement, which is that if you are not affected directly by something, then you cannot bring a claim. So it can provide for representative kind of claims. And then when it comes to mandatory legal insurance, that's what I've emphasized at the end of my own article, published article, where if you just look at the numbers, you realize that if employers can provide legal insurance and that it covers dependent, it has at least theoretically the possibility of covering either the entire population or close to the entire population. It's just that in practice it may encounter some resistance either from employers or employees, because it would mean less disposable income as the employers takes money to cover them to cover the employees in case of legal disputes.
Of course. Now, Mr. Brian, your research proposes Umbu as a theoretical framework for expanding legal standing. How would you incorporate this in an African philosophy, change of how our courts operate, and do you see any resistance to this approach with Namibia's legal establishment?
I don't really see a resistance per se, because I think it's just a matter of training our judicial, the jurors, and how to approach this. The Umbu. Umbu basically says, I am because we are. So basically this, I would say, politics of chasing people away from the court because they don't have a certain requirement, they don't meet a certain requirement, is quite far-fetched. So what the Ubuntu principle would do would basically enhance the principle of solidarity, community. We are all Africans. So if you, for example, bring a case before the court on behalf of my group of people who are affected by a particular issue, they would hear you, because the Ubuntu principle enhances that. It will enforce that the judges, the magistrate will basically be put in a position to hear cases that are brought by individual, because Umbu is basically a principle of togetherness. We are a family. So if I'm affected, at some point you will be affected. So it's a matter of communityship. So
Brian, you want to add on that? Thank you so much.
Thank you so much.
You want to add on that as well?
No, I think Mr. Guchinhazo has presented that very effectively.
Okay.
Yes.
All right. Lastly, just perhaps to hear from you on your research papers. What do you intend to achieve with these papers? And of course, I understand, like in China, for example, when they publish papers, you don't just publish for the sake of publishing and have your research out there. There needs to be implementation with it as well, because you did a lot of work. You found answers to questions that were being, the people were seeking. Perhaps, what is the way forward with your research papers? I think both of you can answer on that.
Yes, thank you very much. Well, the idea is was to inform policymaking. So the idea is to try to help policymakers in trying to improve the situation. And you are also playing a part in this
Yes.
because you invited us on
course.
the show. So this allow us to share our ideas with with a much broader audience, so that they can also on their side try to advocate for some of these policies to be passed. The Small Claims Court, the Standing in Civil Actions Act, and also possibly also the mandatory legal insurance. I believe it can go a long way in making sure that people can afford it, because currently when we talk about legal services, we are talking about 700 Namibian dollars for junior lawyers to 2,000 for experienced lawyers. That's what they charge per hour. And if you look at the fact that the average income in Namibia is 5,000 Namibian dollars, you realize that most of them cannot afford. As I said, about 90% cannot afford cannot afford legal services. Yes.
Yes.
Well, my paper, I'm just hoping and trusting God that it will enhance their approach of Ubuntu, where people will be heard. Article 12 of the Namibian Constitution is clear that the sound of fair trial, right? Everyone has a right to a fair trial. It should be upheld. So the Ubuntu principle will thus enforce and will help our judges and the court or the litigators to hear cases from all levels, regardless of socioeconomic status and other social impacts. So basically the paper is just there to encourage the judges, the legal practitioners to help these people heard by the courts, because I know of some activists that I mentioned earlier who would always having that dire desire to represent people in court or to bring a case, but because he can't, because he's not directly affected, but because of the Ubuntu principle, he can be heard, and the judges should pay attention and be trained on the principle of Ubuntu.
I don't know if this is part of your papers, but currently on your findings, how are Namibians now, those, the 90% that you mentioned, how are they accessing these services now, those that are unable to afford it? Is there like some platform where they can go to get to be helped, or how does it go?
Well, there are platforms, but it's insufficient. So we're talking about the Legal Aid Directorate in the Ministry of Justice. A few years ago, the budget was about 18 million. I quoted it in the research, and only about 10 million goes for legal representation. That is not enough considering the amount, the need of legal services. There is also alternative dispute resolution, so that's when you're trying to resolve an issue outside of court. There are limitations there as well. So, for example, it was found that when it comes to high court connected mediation, the success rate is about 50%. So this is another way that there's one chance out of two that it will fail. So it's not very effective, although it helps. The Deputy Chief Justice, Justice Damasen, has published an article that shows that we can save per year, 100 million Namibian dollars in litigation costs through this process, because currently, if you're talking about a case that is defended in the High Court, we're talking about 50,000 to 100,000 per cases. So there are mechanisms, but they are limited. In criminal cases, we have prosecution, so it's done by the state. But most of the disputes do not involve criminal cases. So for family issues, succession issues, for issues dealing with property and so forth, there's simply not enough. You have community courts. This is also something that people have access to, but the problem with community courts is that the jurisdiction, the authority that they have is limited. They cannot deal with certain type of issues, such as certain types of property issues. So there are platforms, but they are not sufficient. So what it means is that in practice, people do not get nearly as much legal services as they need. In fact, part of the problem is that some citizens would not necessarily realize that the problem that they face is legal in nature, and that also requires that legal services be available. Yes.
Does your paper also address that?
Not really.
Okay.
I'm relying very much on the Ubuntu principle and how the courts should be trained and change their approach to to the marginalized, the small, the minority groups. I'm more focused on that and how the courts could welcome them in a court via representation by you, representing your constituency, for example, although you are not directly aggrieved, but you can still stand in a gap. So I'm more on that. Prof is quite informed.
Of course.
You
and
can tell.
I'm sure you engaged with the marginalized communities, and how was that for you, and what are some of the findings when engaging with them when it comes to legal representation?
So my paper, as Prof. earlier mentioned, is on the Tumep's case. It's a case that took place a while ago where a group of people lost their land in Tumep. They approached the court saying, hey, we lost our land, we want our land back, but then they were chased away because they didn't have direct standing. So how I found most of the reaction is that it was unfair. They felt really harshly treated by the system because they don't have the money, and the particular person who brought it for them has the power to bring it, and the traditional authority that was supposed to stand in the gap is compromised because they are on the side of the government, so they didn't trust the traditional authority, so they felt quite more marginalized as they are already. So it's quite heartbreaking because it's not only them, there's a lot of groups. You got the people from the different sexual orientation who also want to be heard. We got people who are living with disability who want to be heard. So these people feel that they are being pushed to one side, and it's like the Namibian courts are relying on apartheid or colonial laws or the Western ideology of only listening to one individual person who's aggrieved. So I feel that, and they feel that from the reading that I read, that they actually bad done by the system.
Prof, you were seeing his paper. I mean, what are your comments on what you found so far?
Well, it's an advanced, at an advanced stage, and I find the research fascinating, and I'm sure yourself, by listening to it, you can see the passion, and you can see it's very insightful. I think there's a lot to be written in the field of access to justice, because as I said, it's a foundational principle of the Namibian state. But not a lot has been covered in the research. His research is very original. In Namibia does not yet have class actions, which is looking at, it's only covered in limited cases in labor disputes, but it's something that could actually go a long way in making it possible for many Namibians to get justice through the courts. Yes.
Where can we find these papers? Once they are done and published, yes.
Well, mine has already been published. It was published in 2021. His research is quite advanced, so it should be published, I imagine. But it will depend on him, so it's it's best to ask him, but it should be completed by November.
But where do we find yours?
It's on if you Google on the internet, it's called the price. Nobody can afford legal services. Nobody can afford legal services. It was published by a South African journal, the Potchefstroom Electronic Law Journal, in 2021. So that is already available online. Yes.
How will we find your article?
I'm under the University of Namibian system. So they own all the publications. So Prof would know better how one can go about accessing some of these publications.
Let's just, Prof, what is the need for you? You said your publication was in 2021, right? Why do you feel is a need now to come out and advocate for it again?
It has been an ongoing process. I mean, since 2021, there have been developments in that sense. I was approached by a journalist who was interested in the question of access to justice because, for example, we learned that in the fish fraud case, former fisheries minister Bernard Esau said that he doesn't have any money to pay for the legal services. I understand that recently he was given access to some of the funds. It shows that even for people who relatively have a higher income, access to justice remains a luxury. It was not the intention of the drafters of the Namibian constitution for access to justice to be a luxury. So that is the main problem. So since the publication, and even before the publication, access to justice was a problem. Today it's even more of a problem because of the cost of living crisis, because it means that if it was difficult before, it's even harder today. So we need to find urgently solutions so that people can get justice, and justice also plays an important role in maintaining a stable and prosperous society.
Thank you so much for being on Namibia Connect this morning.
For inviting us.
All right. All right, that was Professor Dunia Zongwe, and who's an author, consultant, and an academic, joined by researcher Brian Gucci Nado, who they just gave us a brief on the research papers that has to do with legal representation, especially for an ordinary Namibian